Hi, this is Janet Brewer. One of the questions I'm frequently asked is whether you'll be able to keep the same property taxes on a house that you inherit from your parent that your parent was paying. Suppose your parent's house is worth $1.5 million and that the current property taxes are $400 a year. There are several tax issues here. Property taxes are under Prop 13. Income taxes or capital gains taxes need to be considered, and then there are estate taxes. For property tax purposes, you can keep the same property tax as your parent was paying if the house you inherit was your parent's primary residence. If it's a rental property, then you can keep the same property taxes on the first $1 million of value. In order to keep the property taxes the same, though, you will need to file a Proposition 58 Parent-Child Reassessment Exclusion Form with the County Recorder's Office at the time you inherit the property. If you fail to file that form, your property taxes will increase. For estate tax purposes, how much you will pay in tax depends on the estate tax laws at the time of your parent's death. This year, the first $5,120,000 of your inheritance is free from estate taxes. Next year, however, only $1 million of assets will pass free of estate taxes. By the way, assets includes everything your parent owns, even life insurance and retirement accounts. If your parent's estate is worth more than $1 million and the tax law hasn't been changed, the tax on the excess will be substantial, up to 55%. Capital gains tax treatment, too, will depend on the tax laws in effect in the year your parent passes away. Under the current law in 2012, your parent's house would get an adjustment in cost basis for capital gains tax purposes. We would not care what your parent paid for the house. All of the capital gains would disappear at the time of your parent's death. So, for example, even if your parent originally paid $50,000 for the house and it was worth $1.2 million when your parent died, you would not owe any capital gains tax if you sold the property for $1.2 million or less. You would only owe capital gains tax on the increase in value after you inherited the property. If you sell the property for what it was worth on the date of your parent's death, there would be no capital gains tax on the sale. Of course, if Congress changes the tax laws in the coming congressional year, then the rules will be different. This is Janet Brewer. If you need an estate planning attorney in California, please contact me at www.calprobate.com. Thank you.